St. James, Mrs. Malahoo Ford, when she was the Attorney General, being MP in West Central St. Andrew, what happened is, when you're in the cut and thrust of the parliamentary debate, and you get to see the concerns of members that are raised, in a way, you have a nuanced understanding of the issues that concern the members, such that you can instruct yourself as Attorney General or have greater clarity on the instructions that you are to be getting from the government as a chief legal advisor. And because of that, the opinions that came from the Attorney General, because of that interplay, I think they were more understanding of what was required, because sometimes the instructions on paper don't quite capture the nuance of the debate unless one is present within the chamber of the parliament or one is meticulous in watching and understanding what is going on. Yeah? So we've lost that because the Attorney General no longer sits in the chamber. Right? But in terms of when you're a minister and you're leading policy, not only do you need to have clear idea as to what the issues are, but when the bill is drafted, you need to be able to defend it based on your understanding of the gap you're trying to fill, and you need to have a good understanding too of the Constitution and to see whether provisions in the bill may offend sections of the Constitution, and if they are claiming to offend it by members of the opposition, then you need to be able to defend what is on the floor of the parliament. And you have a very sharp legal mind like Mark Golding, who is going to bore holes in a lot of what is presented on the floor. And if you do not have somebody who is meticulous, I keep using this word, then a lot of bills are going to have to be withdrawn because you don't have the people who draft the bill sometimes before the parliament to respond to the questions, unless it is before a joint select committee and so forth. Yeah? So that's why I say a rethinking needs to come in this instance. So thank you for the people who've sent in on Kamina Johnson-Smith and so forth. She's in a different chamber. Yeah, she will defend the matters up there. Yeah. All right. 876-926-2178, 926-8631, 926-761-5888, 991-2080. So a lot of by-elections may be coming up soon because of the indication from some people that they won't serve a full term. So we shall see. A lot of disruption expected. 9262178, I'm with you.
Blessed one, Chief of the Shields.
John, how are you?
I am doing fairly well. Just might have had some medical issues, but I'm feeling well. With the Shields, I am not surprised that Mrs. Malahoo Ford is not in the cabinet per se. And the reason I say that, Mr. Shields, is because I remember when she was Attorney General, the amount of blunder that was made every time they got court, and she advised the government rules. In this dispensation of
like which one? Which matters?
You know the matters in the Shield, state emergencies, about 5 different matters, and the government lost.
So, is it the case that since this new Attorney General is there, the government has not lost any cases?
They have lost 2.
2?
Yeah, I was 1.
Really?
Yes.
I tell you already, and I'm going to let you finish your thought, John.
So, some of the she's...
No, hold on. I'm going to let you finish your thought. But let me tell you something. The fact that an attorney loses a case, it doesn't mean the attorney is not a good attorney. Some cases are not winnable.
I wouldn't never say that.
Okay, but I thought you said she loses cases.
Government attorney, the person who is responsible to government, you supposed to know the thing that we're going to make the government get a court or not.
No, but
it's... I stand down and say, no, okay, I think we are going to, this is not, we're not going to win this.
No.
So you can't see it.
No, John, that's not how it happens.
Oh, so you bring everything
no, let me explain. For example, the state of emergency. The proclamation is issued to say there's a state of emergency somewhere in St. James, right?
Yeah.
You have the police who are operating under the state of emergency who detain people according to whatever intelligence they believe they have. They hold the people for whatever time they think they need to hold the people. The Attorney General may know that people are being held. The Attorney General has no jurisdiction to ask any questions about the circumstances of the holding. But 1, 2, 3, or 10 people out of the group that is held decide to challenge their holding and to sue the Attorney General based on the Crown Proceedings Act. So they take the Attorney General to court. For the case to be properly defended by the Attorney General, then the police or the soldier who is holding the individual, they have to give affidavit evidence in most instances as to why the individual was held for the time that they were held. And then the court will look at it and decide whether, you know, the evidence that is given in the affidavit, whether it meets the constitutional threshold to say that the holding of the individual is justified in a free and democratic society.
Mr. Look here. You see what I read my role, it's not saying anything.
Okay.
Let me tell you something. Even in this case, it was telling Parliament that the way you are going about this is incorrect. The authority at the time didn't listen and said the country said, boy, yes, something is wrong here. Let us work it out this way. They proceed and they got a court and they lose. So the thing I'm talking about when she is yes, sometimes something come up. And because they're stiff-necked and wall out. It got put in by the government. But anyway, I didn't expect to see back Mr. Malawood. Oh, I never expect to see back one name Arbin Hill. Because Arbin is one of the worst trade ministers Jamaica has ever seen. From Arbin Hill has been in that position. I don't know one place Arbin has gone and you have write a new trade agreement with Jamaica. No way at all. Because you can't find it. So I'm surprised Arbin is still there. I thought that the minister at Miss Arjamax had about the digital transformation and things like that could have gone into the Minister of Industry and Commerce, and she be the minister. So it surprised me when we see Arbin is still there. But you know, that's the way the JLP works, so we're not really criticize. We're not really talk about. What I want to talk about this time, Mr. Shield. I am so sorry for these people with disability who are going to lose out. The PMP, I'd say, was a special fund for these people. People with disability have been struggling in this country for years. And somebody come who have a vision and say, watch out. For your education, your nutrition, and if you want to turn entrepreneur, we will provide you with funds. I wonder if the JLP government is going to look into a matter like that and take it on board. Well, because the people say, you're fly green. I'm just saying something. President Charles Jr. was a much better agriculture minister than fly green. I remember for years some tractors were down. And it was President Charles Jr. coming in as Minister of Agriculture who took on the issue and get this tractor up. Were that enough? Well, leave him say I think. Since Flag Green come back, he hasn't bought one tractor. One was donated to him the other day. they donate. The government hasn't buy one.
But all those things that you're talking about, I don't even know if they're properly functions of a minister. To go buy tractor and all them something.
You as a minister, so still need other people.
No.
Look about. But anyway,
No, you put policy.
The growth agenda.
Policy directive. Hold on, John. Let me please.
You see, even this growth business is, this government has not been able to grow the economy by more than 1% since per year. Since they've been in power.
It's not unique. It's not unique to the government, though. It's not unique to this administration.
No. Listen to this. This is the best time. The PMP, the PMP administration, did that heavy lifting. The people have tightened their belt. As a matter of fact, the people have tightened their belt, and we have reached a certain level where we expect that growth is to be accelerated. There'll be no growth. I don't know in no industry that is coming on stream to accelerate this growth. So it's pure awash.
No.
One minister.
No.
I see there. Who I hope they might do something.
Yeah, well,
it's First Charles Jr.
No, there are
minister.
There are a couple of
But
things.
I want to
hold on a second.
By his cabinet, by his slate of
all right, John.
Of senators.
John.
Wonderful. Cleveland. Tomlinson. Ferguson. Good youth. Kisha Anderson. I think these people are going to do the work for the people of Jamaica.
All right. Thank you for your time.
Yeah.
All right. 876-926-7615. Morning.
Morning, Mrs. Shields. How are you doing?
Not too bad. And you?
Not bad, man. I haven't heard from you in a very long time.
Is Roddy?
Yes.
Yes, very, very long time.
Right. Like yourself, I'm surprised that Mrs. Marlene Malafo Fort is not named in the cabinet. I'm here thinking, I don't know if you can help me. What could be the likely reason or reasons why she was not named?
I don't know.
Before you answer, even if a position becomes available in the office of the Prime Minister, to me that would be like a demotion.
Well,
so, I don't know.
Yeah, I can understand that thinking, but if the Ministry of Justice is now Justice and Constitutional Affairs, and Delroy Chuck is selected to head that out of deference to his political seniority, then Marlene, if offered a minister without portfolio in the office of the Prime Minister with responsibility for constitutional affairs, could perhaps not see that position as a demotion, but could seek to understand the political realities that play, because after all, this is politics.
Right.
And understand as well that Delroy Chuck has indicated that he will not be serving a full term, so she will perhaps ascend to that full.
That's the other point I was going to touch. The fact that he's not seeking a full term. With what sense does it really make sense? To me, it should be the reverse.
Yes, I agree with you, Roddy. It should completely be not only because he's indicated that, but because he hasn't got the capacity to handle that full ministry. But listen, there is a lot that goes on in terms of the juggling for a Prime Minister, perhaps with the harsh political realities in the back room. We saw where in North Central St. Andrew, where Carl Samuda, who's been over 40 years or so, the MP, having switched from one side to the next, an announcement was made by Horace Chang as General Secretary of the party about who is to succeed Carl Samuda, and that Carl Samuda wasn't going to go back. And Carl Samuda took serious offense to it and made his offense known publicly, and that threatened the stability of that party for a long time.
Right away.
Yes, such that Delana Seabright, who was not chosen from our understanding to be the candidate in the last election, expressed a desire to go in, even though Christian Tavares Finson, I believe, was selected by the party. And the thing has now completely been upended to the point where what happened in the election? The Lana Seabright ran and won, and Christian Tavares Finson is now in the Senate.
Right, well, politics.
Yes.
Politics and politics kind of work hand in hand, you know.
Yes. So I think that's probably what is at play. It could be no more than the recognition of Delroy Chuck's continued contribution to the Jamaica Labour Party and to see him out in all of his glory, however incapacitated he gloriously is.
Anyway, Mrs. Shields, as you rightly said, the head of the opposition, Mr. Mark Golding, he is no step over, you know. He knows the Constitution. He is versed in his field. So I don't think the PNP in this new administration will be a step over.
No.
So whoever they choose, or whatever position they have to bear, all these matters in mind. However, I was listening to the news this morning, and I think it was Dr. Chang was basically the opposition was saying, I think the leader was saying, and other members, they would be objecting if Mrs. Holness or Mrs. Dalrymple are recommended for Speaker of the House again.
Yes.
And they say exactly why they say that. And what Dr. Chang was actually saying, basically, they no have no talk. I don't agree with him. They have a lot of talk because they would have to support that person. Am I correct? Now that they have majority in the House and they still have their own senators. Am I correct?
I'm gonna double check the standing orders on that, and will give you my thoughts on it, because I initially, certainly, having watched the Parliament, I certainly thought in the last Parliament that Juliet Holness would be a good speaker, and she went up there. Looking at it now in the new term, and with the issues raised by the opposition, and the issues raised having personally impacted, bruised, irritated the Prime Minister to the point where in one instance they walked out of the chamber, the government walked out of the chamber because of the Golding broadside. It perhaps will be foolhardy in this term for the government to decide on reappointing Mrs. Holness as Speaker. And I don't see that it will also be, I don't think it would be right for them to put back Mrs. Dalrymple for the bird either.
That's my personal view.
Yes.
I share your view. So, let me ask you something though, divert a bit. That case with Mrs. Dalrymple, was it solved in court? Did the court, it settled in court?
Yes, I think she pleaded guilty.
There
was a preliminary point that was taken by her, and the judge decided against it. Didn't decide in her favor, but I think she pleaded guilty because the breach with which she was accused, it's an administrative breach, you know. So she paid whatever fine there was.
I thought as much. So it was more like a fine. So if my memory serves me right, it would boil down to some duties that should be paid on a visa or something like that.
Yeah.
So it would boil down to a fine.
Yeah, that's what happened, and that was settled before the election.
But I tell you the truth, Mrs. Shields, being in government, it's not good to have those sort of situations either, because when you're in the public eyes and you're representing the public, to me, there should be transparency. Everything you do, you must remember you are in the public. You're a public servant now, And I'm not saying any wrongdoing, whether in public service or not, is wrong, but more so. But I fully support the opposition. They should not, either those two ladies should not go back for that position. That's my personal view.
Yes.
And you seem to share my view.
Yes,
too.
Amen. Thank you.
Mrs.
Thank you so
Shields,
much. All right.
Have a great day.
In fact, as I said, Delroy Chuck served as speaker before. That's what should happen. He should go up there as speaker. Thank you, listeners. We're back with you on the hotline. I'm joining now the Director of Public Prosecutions, Paula Llewellyn, King's Counsel. Good to have you, King's Counsel.
Good morning, Mrs. Shields. Good morning to your listeners. May I say that you may be in your 51st year, but clearly age is just a number.
As it is for you.
Well, I'm in my 65th year.
Don't I know that? Yeah.
And I am told by a lot of persons that God continues to be good to me.
Yes. Good.
And as a gentleman in the supermarket said to me, Miss Llewellyn, what a way the stress agrees with you. So...
And tomorrow the stress will be lessened. Let us welcome as well Senior Counsel Bert Samuels, who is a member of the Advocates Association. Counsel, good to have you, and I'm sure you are aging well.
Yeah, I'm fine.
Yes, I saw you the last time. I couldn't even guess the age because, it's just all glow. So good to have you. Maybe I can start with you based on the position put forward by the Advocates Association. In the paper this morning, I see the Gleaner is reporting that President Tamika Harris wrote a letter to the editor in which she's saying that the DPP's office is using its authority to block judge-alone trials in a way that undermines justice and delays the legal process. Just explain some more about your understanding of where this statement is coming from, Mr. Samuels.
Yeah, well, firstly, the DPP is using their statutory rights. I mean, they are using their statutory rights to do that. They can object to the application by an accused to be tried by a judge alone. They can object. So they are exercising their statutory rights. So we are looking at another consideration is one of best practices and the role of the DPP, which outside of statute, we know that they are not supposed to be aiming for convictions. They are not supposed to be judge shopping. They are supposed to want to make sure that matters are tried expeditiously. Those rules which do not operate as legal rules, they are just practices which the DPP ought to practice. Then that is what we think offends the objection to a trial by a judge alone. So your listeners should know that when a man comes before the court to be tried, they can be, the accused can say, I want to be tried by a judge alone and not a jury. And he, in his own wisdom, say, listen, I'm in custody so long, they can't find enough juries, let this judge alone try. The DPP comes in and says, no, we are objecting to this. And they're exercising their legal rights. But we are saying that based on the principles of prosecution and prosecutorial best conduct, we are surprised that they would want to object to a particular judge trying a particular case.
Yes.
That's the thing.
DPP, tell me, I know the law was amended in 2015 to allow for an agreement in writing between defense and prosecution. What was happening at the time? Why, with all the considerations that counsel spoke about, this statutory position was given to the prosecutor to agree or not? And if there's no agreement, then there can be no bench trial at the election of the accused.
Well, I believe that in the same way that finally Jamaica came into the 21st century and we now have the right of appeal being given to the prosecution, it perhaps was just the authorities were following best practice. You see, the days when we used to think that justice was only for the accused, those days are over. The overriding objection, as has been reiterated in many cases, is a trial process that is fair to the accused. But it does not mean that it commands the prosecuting authorities to roll over and play dead. And anything or nothing at all that the defense may be putting forward to the court, then we sit there mum and say nothing. And this whole issue of judge shopping, when I saw this, I said to myself, sometimes these things are said because it is known that a lot of people out there, they really don't know what the system is, which is why I made it my life career journey to try to educate the public. First of all, we have a criminal case management system that is in place. And in the criminal case management system, both the prosecutor and the defense counsel have particular responsibilities. The DPP's office never ever knows unless, for example, it is in the parish court where just recently my team advised me that the authorities from CAD indicated that a special assignment of a judge has been made for the trial of the Royal Reed case. And it is a judge that comes from Trelawney. Right? But in the circuit court where the jury sits, the DPP does not know, when we have criminal case management, who the judge is going to be in any court. Once the matter is deemed by the judge, having heard from the prosecutor and the defense, what exactly is outstanding? Is the matter complete? Are we now ready for trial? Then the matter is set by the court authorities.
Right.
For a particular court.
Stokes, I hope I'm going to get equal time.
Yes, you will.
The DPP's office is not party to the decision making in respect of where matters are listed for trial.
Let me hear.
And let me say that in our experience, and remember, unlike a defense counsel who comes into court with 1 or 2 or 3 cases, the DPP's 58 lawyers operating island-wide in all the circuits. We handle thousands of cases. We operate by the high tradition of what it is to be a prosecutor,
right,
that is putting forward the best case, but we are not a part of which judge is going to try.
Let me hear Counsel Bert Samuels on that, especially if the Advocates Association is saying that the DPP's office is using its authority to block judge alone trial. How does judge shopping come in when you're saying they're electing not to go before judge alone, but before judge and jury?
Yeah, I think it is well known that Ms. Llewellyn may have another 24 hours,
yes,
or a little more as the DPP, and I just hope that her legacy would have been richer if she took the principal position that she had taken in the past, that she thinks that judge alone jurors, trial by jury, is better than a judge alone. She's on record as having said that, and I joined with her recently in an article I wrote. I commend her. One of the few things we have agreed on, that she believes in the trial by peers to be superior and better than a judge alone. She seems to be retreating from that position by the position she's now advocating. And so that kind of bothers me, especially based on the fact that she'll be leaving her throne shortly. But that outside of that, also, the legacy that I hope that she would not repeat here or ever is to ever equate the rights of the accused with the rights of the prosecutor. In law, we are not equal. And that is why she has to show us her prosecution. She has to give us statements. She has to tell us what her case is about. We have no such duty. So please do not put out there that the prosecution and the defense have equal rights in the courts. No, the accused has more inherent rights than the prosecution. And the duty and the burden rests with the prosecution. And the judge shopping to the public means that when they see a judge that they figure is reasonable or is going to decide the case a certain way, which is meaning and is going to try the case in a way that they may not get a not guilty verdict. They may get a not guilty verdict. They don't want that judge. And that is what we say in the highest tenets of the prosecution. You should not be fighting for a conviction. What you should fight is put the case up and let the chips fall where they may. That's not the principle that the Miss Llewellyn is leaving as a legacy in the DPP's department, and that's sad.
But is the legacy Ms. Llewellyn's, or is it the statutory amendment?
It's a statute.
That came, which
It is
you
a
said
statute.
before,
We have a
Mr.
statutory
Samuels. Yes.
right.
But that's how I started.
Yes, that's how
I
you
think
started,
saying
right.
It's a statutory right, but the best practices don't necessarily mean that you use the statutory right in the way that you're doing it.
But-
That's why it's called best
Hold
practices.
on. Oh, let me ask you this, DPP, because one of the points made by the Advocates Association is if the prosecution does not agree when the accused elects to have bench trial, then it means that the commencement of a trial is likely to be delayed because a jury has to be empaneled. Are you concerned that election, the empaneling of a jury, may further eat into the right of the accused to a fair trial within a reasonable time?
No, I'm not concerned because, as I said, we deal with thousands of cases. And when you talk to all the prosecutors, because yesterday when it came to my attention, I spoke to several of them, and we all have had the experience. If you were to do accounting, the statistics would tell you that most of the cases, it is the defense who want to have a jury trial. Because the perception is that if the accused comes from the community, the jury from the same community will see and feel sorry for him and or maybe open to certain other things and acquit him. But if you look at the statistics, Mr. Summers, though he has had a long history as an attorney, but he still would not be privy to the statistics in terms of the thousands of cases that we have done over the years. And I cited Mario Dean's case. The records will show that in an effort when we realized there was a jury issue in the St. James Circuit Court, over the course of at least 2 or 3 years, especially during COVID and just after, we begged the defense to let us have a judge alone trial.
I tell you what, I'm up on headlines. I'm up on headlines. Hold on, gentleman and lady. Let me come back with both of you because I'm up on the headlines now. We must continue back with you on the hotline. We are rejoining the Director of Public Prosecutions, Paula Llewellyn, King's Counsel, and Senior Counsel Bert Samuels, a member of the Advocates Association, based on a letter to the editor by the Advocates Association calling for a review of the law governing the election of an accused for trial by judge alone, and which election has to be agreed by the office of the DPP before a judge alone can sit in some trials. DPP, we're back with you, Mr. Samuels.
I am here.
Thank you so much. Before the break,
I'm here.
Yes, before the break, you were telling us what about the Mario Dean matter, DPP?
I was saying that given the history of the matter and the fact that we lost a defense attorney in the matter due to his untimely passing, it took many more months to get a new attorney because, of course, we cannot try the case unless the accused persons are represented. I once prosecuted a case, the case of Michael McLean, where when you looked on the history of the matter, for nearly 12 years, the matter had been there. It was a 6-count murder case, 4 children and 2 adults, and Mr. McLean had changed about 10 attorneys, and we had to wait.
Is this part of the discussion?
The thing is, please allow me, Mr. Samuel. What my learned friend seems to be suggesting that the prosecution, yes, we will always make sure that we are fair, but the prosecutor is an advocate also, and we are obliged to follow the law. Therefore, if, for example, defense counsel makes a no-case submission, and we know that as a matter of law, there is a case to answer. What is my learned friend suggesting? That because we are prosecutors and we are just supposed to put up the case, we should stand up there and say nothing?
You know I can.
No, because we can't do that. We are obliged to follow the law. The law allows us and gives us a statutory right to decide.
So is it that,
Yes,
Mr. Samuels,
there must be agreement.
is it that the Advocates Association will be seeking to have the law amended?
Yes, that's why. At the beginning, I said it.
Well, that is what they should do, and then we will respond.
Yes, just hold on.
Am I being helped by Ms.
No,
Llewellyn? You know I don't need the help.
Yeah.
I don't need the help. Thank you. Yes, I don't need the help. Okay. Yes, so to answer that, yes, we're seeking an amendment to the law. At the beginning, I said that it is the law and they have the right to be. But I want to ask the question through you, Ms. Shields, whether it's the opposition to a trial by a judge, when the accused says, I want to be tried by this judge, is it that they fear that there will be an acquittal while they oppose it? What is the reasoning behind opposing a judge alone?
The reasoning behind very often,
be honest, please.
To all experienced prosecutors, when you have a credibility-heavy matter, we have found that the original reason why you had trial by a judges of your peers holds true. You may have a situation where there are going to be certain terms, and I know of a case, and there have been cases where, for example, in a rape case, it was quite clear that the judge, when the complainant said that she was raped from behind, the female judge, was clueless and was going to no-case the Crown. And the Crown had to fight to show the judge that penetration of the vagina can also take place from behind. The judge was not aware.
What?
The jurors were aware, however, and in fact the jurors convicted.
But,
so we have seen situations
well, I think we lost Mr.
certain cases, our assessment of the case. One, the jurors, the people in the community, as a matter of the interest of justice, should be involved in the trial of the matter, and that we believe that given the circumstances of the case, because it's very heavily credibility focused in terms of the assessment of the witnesses, that the man and woman in the street with their common sense, we believe, would be better placed to properly evaluate the credibility of the witnesses.
Are you intending, if there's not something yet, are you intending to add to your prosecutorial protocol the considerations that apply when you are electing for trial by jury?
No, that would not be necessary. We have a decision to prosecute protocol. We have a Jamaica prosecutor's manual. We have a disclosure protocol. That is not necessary. We do in-house seminars all the time, and that comes with experience. We have a structured program of mentoring in the office, where when you come in as a young counsel, you're assigned to a senior counsel and somebody also seasoned at your level. That is a matter of experience, and each prosecutor is an advocate and has to make the assessment depending on what is happening on the ground, what the circumstances are, and because there are chambers with over 50 lawyers, the prosecutor can always consult or collaborate with other more senior prosecutors.
Right. We're trying to reconnect. We're trying to reconnect with Councillor Bert Samuels, whose call dropped a moment ago. So is it then DPP? I know it's your penultimate day in office, but do you anticipate that if a request is made by the advocates to the amendment to the law, I believe Mr. Samuels, let me try and connect Mr. Samuels on my cell phone now. Mr. Samuels, can you hear me? I'm back with you on the hotline on here. Can you hear me?
Yeah, I'm hearing you. Yes.
All right, let's connect you this way because he's connected with me here. So I just want to find out if since the law, let me ask you this, Mr. Samuels, since the law is of recent vintage, only 2015, do you anticipate that your request for an amendment to the law will even be something that is considered, since it's not even 10 years that it has been around?
I think that if we have a parliament that understands the role of the defense and that we are not equals in the courtroom, then we may have a look at it. There are so many lawyers in the parliament, must be the most common profession, that I think we could lobby successfully for that. I'm hoping that it will happen because it is the DPP who lobbied for the right to oppose. So now that we have a new DPP come next month, maybe that new DPP will have a different appreciation for the justice of the matter.
Well, I'm here to tell you that the executive cohort at the office, and I am positive that the new DPP will have the same view that I have. Do you know, Emily, and to your listeners, in terms of trafficking in persons, it was the DPP's office who made the recommendation to the Ministry of Justice that the matter should be taken from a jury trial and only have it as a judge alone. Everything that you are going to do in terms of making recommendation to the policymakers, you don't do it as a matter of feeling. You have to have evidence. You have to have data. And we certainly,
but I don't understand the DPP. She has gone public to say she believes that jury trials are better than judge alone. I don't understand this.
Listen,
I don't understand.
The prosecutor is an advocate, just like a defense counsel. And as an advocate, you have certain responsibilities in terms of the assessment of the law and the circumstances of your case.
But Ms. Llewellyn, tell the public whether you supported jury trials over judge alone trials. Can I hear that? Did you do that? Can I read the article from the Observer where you said
I have
that?
Always indicated the hybrid approach. I believe I have no problem with
didn't use the word
trials.
hybrid.
Listen, this is my view. Allow me to speak for myself, Mr. Samuels. My position as that of the office. Please allow me. Please allow me, Mr. Samuels.
Let her complete her
Please
sentence,
allow
Mr.
me,
Samuels.
Mr. Samuels, to state the position of the DPP and the office. We have always advocated a hybrid situation. It is the Chief Justice who was positing that the time had come for only judge alone trials. I respectfully disagreed. And my position, and I know that is the position of the office, that the hybrid approach is better. The law allows and gives flexibility to both the prosecution and the defense. We as advocates, both prosecutor and the defense, on the ground in respect of the assessment of the circumstances, and it is open for us, either of us, to decide with agreement whether it should be judge alone or jury. My position has always been
established in the Bolton case is that
judge alone, no problem, jury, no problem, but let it be on a
Hold on now. Yes, Mr. Samuels.
Well, the principle
yes.
by the Bolton case is that the prosecution must not strive for a conviction. And every time they oppose a particular single judge to try a case, it is because they think a verdict of not guilty is going to come. That's what guides them.
There's no evidence of that,
Mr. Samuels. There is no evidence of justice.
There is no evidence of that, given the criminal case management system that we have in place. There's no evidence of that.
We will look. We will look and see.
Induce speculation on the part of the public. There is no evidence of that.
Let us look and see how it plays out. As you mentioned the new DPP, Mr. Bert Samuels, and you also said the new DPP's thinking will not be different. Who is the new DPP?
What you can do, Mrs. Shields, please write or speak to the Services Commission. That is the entity that will be the best person
we need a new era in prosecuting. Bye, Ms. Llewellyn. All the best in your life after being DPP. All the best.
God will continue to be good to me, Mr. Samuel.
Thank you.
God will continue to be good
on
to
him,
me.
darling.
Thank you very much.
Thank you.
That's okay. He has always been with me, especially when I have to deal with counsel like you. Take good care, Mr. Shields. And as I have been saying previously, my thanks to the public of Jamaica who have been.
Come back with me tomorrow. I'd like to speak with you tomorrow, finally, on your final day. Goodness. All right. Thank you so much.
All right.
Thank you. That's how it goes at the bar. And they will meet and they will have a drink. Fascinating time. I look to see what happens with this matter. Well, thank you so much for the spirited debate, as always. Hi. Who is the new DPP? I'm to write to the Services Commission? Maybe I'll tell you who I think it is. Oh, boy. Thank you so much, Director of Public Prosecutions, Paula Llewellyn, King's Counsel and Senior Counsel, Bert Samuels. Me say, that Bert Samuels, they come in like a Tom and Jerry, you know?